Oh. And let's do one more thing. Okay, Emily, you take it away.
Okay. Thank you all for joining us. It's lovely to see faces over Zoom. Um, because I'm going to have the screen share up here, please just speak up anytime you have a question or a comment, because I probably won't be doing a super job of being able to see like digital raised hands. And since we're a small group, just feel free to chime right on in. Um, so as Stephanie said, I'm Emily Abels. I'm an attorney in Kennett Square in beautiful southern Chester County. Our firm focuses mostly on estate planning and estate administration, but we also have a wonderful set of nonprofit clients, nonprofit boards, and clients who are starting their own nonprofits or other various exciting sort of legal entity questions. So I'm happy to talk to you a little bit about what it means to be a board member of a nonprofit today. There we go. So as a board member, and as you all know, as members of boards, one of your most important duties as a board member is to make sure that the board is acting ethically and in compliance with statutes and legal standards. This board source has come up with this list of other board duties that are generally all a good idea. So it's a good list if you haven't seen this one before, and Board Source is a great resource if you haven't visited their website as well. But we're going to focus on number one today on that list. So we're going to talk a little bit about what the basic sort of legal concepts are to keep in mind when you are serving on a nonprofit board. And then we will go through a couple of sort of like hypotheticals and some scenarios to test out some of these ideas and hopefully have a little bit of discussion. And as I said before, please, if you have any questions, and maybe even before we jump into anything, if anyone has any questions that they're coming to this session with to start, I would love to hear that to make sure that we address that properly.
Okay.
I might have a specific question about a specific scenario, but I think we can wait till the end for
Sounds
that.
good. Yep. And also, if your question feels specific in a way where you don't want to put it on a recorded Zoom call, I understand that, and we can touch base as well. So yeah, this slide always makes me giggle a little. So Pennsylvania, welcome to Pennsylvania. So we are governed by the Business Corporation Law, otherwise known as the BCL. And this sort of sets out the basic requirements for corporate entities and nonprofits in Pennsylvania. You all are already sort of past many of these points because you're working with organizations that have done all these things already. But just, briefly, you have to have a Pennsylvania address. You have to have a clear purpose, have to register your name, have to have somebody in Pennsylvania who can receive service as your registered agent. You will have already filed articles of incorporation with the Department of State. They will have to have approved those articles of incorporation, and you need to have boards of directors or officers and have bylaws that you set and review as a board. Those bylaws should cover things like what it takes to be a qualified member of the board, how somebody might no longer be an appropriate member of a board or how they may be sort of moved along, how you vote, what your annual meeting timing and procedure is, and this note also is important. You are required in Pennsylvania to have at least a president, a secretary, and a treasurer in your corporate entity. You may have many more roles to fill on a board of directors, but they'll have to have those roles, those blanks filled in, so to speak. So it's not rocket science here, but obviously these are legal standards, statutes that need to be complied with. And if they are not, there are legal consequences. If there's a board member or as a board, if you are not complying with these statutes and other fiduciary duties, which we'll touch on in a little bit, there could be legal liability for failing to do that. Criminal penalty is pretty unlikely. That would be a pretty specific situation, I think. But there could be civil issues that could come up and could put the organization at risk. So I'm sure none of you are experiencing anything to that level of extreme. I sure hope not. But it is important to know that you don't just have a board of directors who then can kind of decide to change all the rules or follow no rules at all, which can happen. A good sort of default thing to have in mind as a board member, excuse me, as a board member is that there's something in Pennsylvania called the business judgment rule. Excuse me. And this is really the sort of guiding principle behind whether or not your error in judgment that may have led to some kind of corporate loss is reasonable. You were really just asking that, well, I'll put it this way. I imagine many of you starting on boards, and I have felt this way too, start by feeling like, I'm not sure that I'm qualified for this, or I'm not sure that I'm comfortable, or that I know enough about this organization to really be an asset. And you don't need to know everything, but you do need to be a reasonable person who's doing their best and acting in good faith. You need to have the best interest of the corporation in mind, and you need to be exercising reasonable inquiry, skill, and diligence. That means, for one, and I think this is really important, that means asking questions. That means actually preparing for meetings, reading the documents, and speaking up, even if you feel like it's a question that maybe you should know the answer to or is something that may have already been covered. But that's your job as a board member, is to be informed and to make sure that you're exercising, that you're exercising all of those sort of, good and standard human inclinations to take good care of something you care about. So I think sometimes people say, well, we have board members who don't show up or aren't prepared or don't speak during board meetings. That's not a great sign. You want to make sure that those board members are contributing and that everybody understands that that's an expectation of being a member of the board. Getting more into the good faith definition from earlier. So you have a duty to make as a board member to come with informed judgments. You are supposed to be understanding the issues, to, as I said, ask questions, to get more information when needed, to hire independent professionals to help you ascertain the details of a situation or get sufficient information, especially when it's, about things that are highly specific or legal or property related, any of those things. As this bottom part says, board members are responsible for two pieces of legal compliance. One is to ensure that there are reporting systems and accurate information. And the second is to ensure that these systems do their job well enough to keep an eye on board members and to sort of put up a timely flag if there are issues based on behavior. Again, we're not expecting perfection or for you to only be on boards when you have relevant professional experience or graduate school. It's just that you need to be paying attention and acting in the organization's best interest, and that's playing an active role. let's make sure I can move to the next slide. There we go. No surprise, you are supposed to put aside your personal interest to put the nonprofit's interest ahead of your own when you're acting as a board member. That means respecting confidentiality. That means very wisely engaging in financial transactions. You technically could engage in a financial transaction that benefits you, as well as that situation is disclosed. Most boards will have most boards will have like an annual form that you would fill in that says, do you have any known conflicts of interest, either due to the type of work the board does? Say you're on a school board or the board of a university, are you going to be sending your kid to apply this year? Or, are you going to be engaging in any financial transactions with the organization? That should just all be disclosed and approved by the board itself. And it needs to, of course, benefit your organization and not just you. So, of course, also then we need to ensure that the board is complying with all regulations that go beyond the Commonwealth of Pennsylvania, and that are faithful to the board's own mission and vision. This gets back to the board cannot, the board for a humane society cannot just decide that they want to become an advocacy organization for unhoused individuals. Like that needs to be a formal process of changing scope and focus. That needs to be recorded in your bylaws and recorded with the Commonwealth. So, a well-meaning board can take positive action, but we still need to follow all of the appropriate channels to make sure that we're complying with what has already been filed and what's on record. Just waiting for this slide to change. Let's see. Oh, there we go. Did I go one too far again? Let's go back. No, okay. So there is such a thing as directors and officers liability insurance. This may be new information, or you may all be saying, yeah, we have that. This is an important component, I believe, of board service. It's usually, the long and short of it, there's a lot of text on this, but long and short of it is that it's usually worthwhile to have. It's usually very affordable, and it's something that you should be looking into just to see what it would cost for your organization to have this. It would protect board members, individual board members, and employees and volunteers in the case of a civil suit. Often, the most common, I think, are employment-related civil suits. If there's some issue for, someone's left the organization in an unhappy place and they file some suit, that would be helpful to have. Any accidents at any sort of physical locations owned by the organization. But yes, oh, here we go. Almost 95% of D&O policy claims are employment related. So it's just something that I think is worth looking into because frankly, I think there's usually very little reason not to do it unless there's truly no funding for it. If there are no employees, obviously the risk here is low if the organization does not employ anyone and you are a volunteer board that also is essentially running the whole organization. But again, the costs are probably very affordable in that scenario, and our recommendation would still be to buy directors and officers insurance. So
I have a quick question.
yeah, Amy.
Sorry. When you say very affordable, my organization does have D&O insurance, but I have no idea if it's affordable. We haven't put it out to bid in I don't know how many years, probably 6 at least. So what I guess I feel like we should put it out to bid and or I don't know, that might be the wrong terminology, but like just find out if what we've been paying instead of just every year voting to renew it and paying. We don't have any employees. We have like one contract position, I guess, so maybe that counts as an employee, but everything else is just volunteer board.
Yeah, I think that's a great question. I agree. If you have not looked into this in the last, I don't know, 5 to 7 years, it's probably a good idea to do just a little bit of research, contact some new companies or brokers and see if they can do any better for you. It may also be that, I mean, the other thing about them, there's no magic about 5 to 7 years, but if the organization has changed at all, and this is for anybody's organization beyond Amy, then it's worthwhile to see, okay, does this impact what our costs would be for D&O insurance?
Okay, thank you.
Yeah, sure. All
Can you
right.
hear me?
Yeah. Hey, Steph.
Hi. I was going to just interrupt real quick and suggest that maybe you should put a timeline and do it 3 to 4 years. And you're just looking for quotes is all you're doing, just like you would do with car insurance. You put it out there to a couple different agencies, and see what it comes back as.
Okay, thank you.
Great. So the other pieces of being a board member who's paying attention to your duty as a legal and ethical board member is obviously you want to make sure taxes are paid and any laws that you know of are followed. That includes any withholding that needs to be managed and that employment laws are complied with if you have employees. And then, of course, the pieces that we've sort of alluded to already, but put in another framework are non-management, meaning folks who are essentially board members in name only, and they're not active participating board members, or mismanagement, which means, failing to be an informed board member, failing to pay attention, either being careless or inept. But you can be a regular person. You just need to be a regular person who's doing their best to be informed and asking good questions. Obviously, you can't actively do something that would be against the interest of the board and remain a board member. Though that does get into conflict of interest, you can have a situation where a fiduciary's interest is, there is some self-serving, but it cannot be in a direct contrary, have a negative impact for the organization. Your absolute duty is to the benefit of the nonprofit. So your gain cannot outweigh that of the nonprofit. All right. We're already up to the fun hypothetical portion of our PowerPoint. So I want to pause here before we jump into some of these, because some of you may be bringing real life scenarios that you want to discuss. I don't want to put you on the spot, Joe, but if now's a good time, happy to answer a question, or anybody else, feel free to jump in.
Sure, but can we stop the recording?
Fair.
I have the same question as Joe because we have it together. And yeah, we would appreciate the recording being stopped, please.
I don't know if other members of our board are gonna watch this later or what, like, I have no idea. We were wondering if, like, so our board was kind of split on something early, or like a few months ago. And it was because of like ethical things that we were concerned about. So